Hi, everyone. Welcome to lecture number 2 for criminal law class. As I said in the intro video, this week we're talking about the legal system in the United States. Last week we talked about an overview and a bit of the history. So bear with me. There's a decent amount to cover, and we're going to try to do this as efficiently as we can. So, for those of you who realistically have taken Intro to Criminal Justice before, this should be review, but so the legal system in the United States, we have what is known as a dual federalism system. And what that means is that we have two semi-equal but different legal structures and systems in our country. We have that one federal government system, and we have the 50 state systems. So they are equal. No one state is more important than the other. And the federal system does have what we know as the supremacy clause. So there is federal supremacy, which means that a federal law is the highest in the land, and all the states cannot go against the federal laws. So that's just that brief kind of overview of what should already be known. But this is where maybe not necessarily known this before, but so there are differences between federal laws and state laws. And it has to do with what they cover. So federal laws mainly regulate issues that concern the country as a whole, or, well, not or, it's an and the federal laws regulate commerce and economic activity among states. So it's important to remember, we're talking about commerce and economic activity among states. So it's happening in more than just one place. This is why we say federal has to do with the whole country as a whole or multiple sections, not just one individual. That's where state laws come in. And state laws regulate issues of local charter or local concern. So again, Pennsylvania state laws don't apply to New York State. New York state laws don't apply to Maryland. Maryland state laws do not apply to Texas. Texas laws do not apply to California. They deal with their own local concerns. The other thing that state laws do is they regulate issues or things that remain within their borders. So now it's not only something that is a matter of their own personal concern, it also has to do with their legally defined boundaries, the borders of each state. One thing that is important to note about this in particular is that 90% of all criminal laws are actually state laws. And if you think about it in the grand scheme of things, it makes a lot of sense. If each state has their own set of laws, then of course a majority of the laws that are out there are going to be at the state level, not at the federal level. So while 90% may seem high, and you may be like, that doesn't seem realistic or right, it makes sense because we're counting each state as its own collection of laws. Even the ones that are very similar or exactly the same, they're different laws because they have to deal with different states. So I do want to bring up one thing specifically about how state laws can differ. And that's specifically, our textbook mentions Nevada's prostitution law. How Nevada has 5 counties within its entire state where prostitution is legal. It has guidelines, but it's not the whole state. It's only certain jurisdictions. And our textbook highlights that in 2009, Rhode Island made a law that criminalized indoor prostitution. And before that point, which was a long history thing, they had a whole bunch of other things that technically the way it was written was not completely correct. In 2020, New York City pushed and promised to decriminalize prostitution. It's still in that weird middle ground. It's been working over the last few years. They've been trying to figure that out. And as of July of 2023, Maine decriminalized the sale of prostitution services. So even amongst states, things can change. The whole point that I'm trying to make here is that regardless of what you, I don't want to say what you think you know, but regardless of what you think you know about laws, know that each state does it a little bit differently. It doesn't look the same, and it gets messy. It's a reason why, whether you like it or hate it, making an issue a state's right to vote and make their own laws becomes messy. And we'll get into it in other discussions. But very specifically, I want to talk real quickly about the federal laws, because Article 1, subsection 8 of the Constitution is what is giving, it grants Congress rights, which it really is the federal government receives its authority to create laws from this part of the Constitution. And so these are the rights that are stated in that part of the Constitution. It's the right to regulate currency and coin, which means they are in charge of the purse. They're in charge of what money is in possession, what money goes where, as well as the minting of that. So they're in charge of all the things money related. They have the right to establish a post office. They have the right to promote science and art in this country by regulating the rights to discoveries and writings. In other words, they're allowed to say, hey, this person discovered this first. They have the right to claim that they're the ones who found it, so they get any kind of compensation for it. Essentially, it's to encourage people to go out and try new artistic things, to try and find new discoveries. It's the reason why a lot of advanced medical science and things like that are, funded by the government but run through private and public institutions of higher education. It's literally part of the Constitution. The Constitution also says that Congress has the right to declare war and raise armies. They also have the power to conduct foreign affairs. And that's an important piece because it's related to this next part, because Congress is, remember how I said money? Yeah, they regulate interstate commerce, so trading of goods and services and money between states, as well as foreign commerce. They're the ones that secure conversations and deals about imports and exports with other countries. So Congress really has some of the biggest powers in our country when it comes to big decisions. Notice I also didn't even say the last one, where they make laws necessary and proper to execute other powers expressly granted in the Constitution. In other words, they have the power to make laws as long as it's related to a power in the Constitution. And essentially any other laws. Of course, they have to be passed and approved. But the idea here is that the Constitution grants a lot of power to Congress. And I don't think a lot of people realize that. I say that not just because of our current political state, but because a general lack of understanding of how our system works in the United States is a problem I've seen from several individuals. Not understanding that the president doesn't just have full authority to do things, and it's not just one group that does it. It's a lot of different factors. And this is important because this is how laws are made and how laws are enforced and how laws are passed. There are, and I'm not going to sugarcoat it, we are going to have to talk about some uncomfortable current issues with our country right now about laws. Because there are individuals in government right now who are directly going against law, and that is a problem. But those conversations will come up as they come up, okay? I know it's uncomfortable, but I realize now I said this in my in-person juvenile justice class. I didn't say it for this class. It's important to note the things that we talk about in this class are based on facts and on things that have been established. We're not talking personal opinions. We're not talking belief structure. We're talking the way things have worked and operated and what the standard rules are. We can talk hypotheticals, but it's important to remember that we're not, picking on any one person. We're simply talking about issues and facts of law. All right, so that's the Constitution. So very, 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 very briefly, I don't think I really need to discuss too much about this because, again, should be a brief overview as well for students who have taken Intro to Criminal Justice, or really anyone who has taken history, civics, things like that, even if it was in high school. So here in the United States, we have three branches of government: the legislative, the executive, and the judicial. For our purposes in this class, for criminal law, what you need to know is how each branch deals with laws. So the legislative branch their whole thing is they create statutory laws, the written laws themselves. So within the legislative branch, we have the federal system and the state system. The federal system is Congress, which is broken up into two bodies, the Senate and the House of Representatives. So within Congress, within the Senate, each state has 2 senators to represent them. The House of Representatives get a certain number of representatives depending on the population of that state. And between the Senate and the House of Representatives, those are the 2 bodies that are in charge of creating the laws and passing the budget and all those other things. At the state level, there are state legislatures, and they still have, elected officials. You're not necessarily county executives, but you're not senator, because that still would be at the federal level, but individuals who represent your part of the state will go to occasional meetings in the state capitol and talk about issues. That we do have state systems. All right. At the executive branch's job is to enforce statutes, enforce the laws. And we should know this one. This is the office of the president. So, at the federal level, it's the president of the United States. And then there's a whole bunch of federal law enforcement agencies. That's what one of those links on Blackboard is that I said you could look at. It has things like information on the U.S. Marshals, ICE, BPA, pretty much everything under the umbrella of the DOJ, which includes the FBI, CIA. It's the alphabet soup. Legitimately, for the executive branch, you have a bunch of individual groups who act as the law enforcement agency for them. And then at the state level, each state typically has their own state law enforcement. You have state troopers, and then you have at the lower levels the county troopers, city, things like that. It all depends on how that state breaks it down. But at the top level, much like we have the president, at the state level we have governors. Governors are our top executive branch member for the state, who is kind of in charge of that system here on the lower level. And then the last group is the judicial branch. And the judicial branch is the one that interprets the laws. And much like with the legislative branch, the judicial branch has the 2, the federal and the state. And for the most part, they actually mirror each other. And we're going to talk more about the federal level here in just a second. But it's important to just kind of note that this is the zone that we're talking about, is the judicial branch. We'll talk about the legislative, we'll talk about the executive, but our big focus right now is the judicial branch. So, the court system. Very briefly, every state has a federal court and several state court systems. Federal courts are exclusive, adjudicating only on federal matters, whereas state courts are not exclusive. What I mean by this is that federal courts will only hear cases that are considered a federal matter. You commit theft and steal from the Circle K on Pine Avenue, that's not a federal case. A federal court would not listen to that actual case. That would go to state court. You kill a decent number of people, enough that it could be considered a serious spree. That could be bumped up to the federal court, but it's definitely still a state court issue. You go on a killing spree across 2, 3, 4 states, now it's a federal matter. They're going to hear those cases. So federal courts are exclusive in the sense that they do not just listen to every case that comes forward. But still, we do have federal courts in every state. The important piece about the federal courts is that while each state has at least one, some have more than one. It gets a little complicated. Pennsylvania has 3. Don't ask. We're a big state, geographically speaking. And part of the reason why I said that and kind of wanted to push it a little bit quicker is simply because jurisdiction. Jurisdiction is the issue that comes down to a larger discussion. So jurisdiction is the authority or the visible or invisible boundaries. If you have taken another criminal justice course, especially something like policing or intro, you'll know we've talked about jurisdiction specifically in regards of policing. But it also has a version in the court system. In the court system, the power or authority to hear cases is 100% reliant on jurisdiction. It is the geographic area that the court's authority extends to, but it can also be an invisible boundary. Remember, we have federal courts and state courts. If you commit a crime in New York State just over the PA-New York line, is it PA's job to hear your case? No. It was committed in New York State. Even though it was on the border, if it happened in New York, it's a New York case. So, outside of that jurisdiction, there is another type of jurisdiction that we need to talk about. And there's the 2 big prominent ones. There's original jurisdiction and appellate jurisdiction. And this is where things get weird, okay? Original jurisdiction is that evidence is presented to the trier of facts. Excuse me. The original jurisdiction is the court that hears the case. They are the ones that listen to the evidence and make a final verdict about guilty or not guilty. Appellate jurisdiction is the other big type of jurisdiction in the court system, and that's where the individuals, which are judges, review trial transcripts of everything that's presented at trial and then make a suggestion based off of those things. So, what's important here is that we're identifying right now that there are 2 major differences in the type of court cases we hear in criminal court. And that's an original jurisdiction and an appellate jurisdiction. An appeals case. We're going to talk about that here in just a moment. I have something in my notes real quick. I want to go back one slide to talk about the federal court and the state court. I have it in my notes that federal courts, while exclusive, it's things if it's based on federal statute or on an issue with the Constitution. However, there is one exception that I forgot to talk about, and that's the diversity of citizenship. And that's citizens from different states who are involved in civil lawsuits where the amount exceeds $75,000 can be bumped up to a federal case if need be. That's a fun fact. That's not something that's going to show up on an exam ever. It's just one of those, I think it's worth mentioning to give you an idea of how they look differently. All right. So in talking about the appeals court, this is where we need to talk about something that hopefully you remember from another class, or if you've not had it, let me be the one to tell you. Appeals courts are very different because no evidence is actually presented to a trial, to any kind of court. There's not a chance for you to take the stand and make your case. No. You file an appeal, and a judge, or rather a group of judges, look at the evidence. They look at everything that was presented in the trial, and based off of what type of appeal you're looking for and what kind of claim you are making, then looking to see, was that claim valid? If it is, what is the response? So we'll talk about that in a little bit more specific thing here in just a second. But, so very specifically, there's this term that is this power, and it's called certiorari. That's the big fancy word that's up there. I'm not going to ask you to ever have to spell it for me, and I'm not going to ask you to pronounce it, but it's certiorari. Certiorari is important for big federal cases. We're going to talk about when we talk about Supreme Court later. But this is the power to seek judicial review of a lower court decision. What this means is that your power of certiorari is to seek judicial review, somebody to look at your case and make a judgment based off of that lower court decision. You can't get it of the same court. It has to be of a lower court. And so when they look at the appeals, like I said, there's no new evidence. They typically review the trial. They review the documents and everything for error. They're looking for whether it's an error of fact or an error of law. But what they're looking for is issues that happened in the original case that will lead to it being an unfair or an invalid trial. And so, when an appeal court looks at a case, they have 3 actions that they can take at the end. They can affirm, they can reverse, or they can remand. To affirm is the judgment stays the same. Essentially, they say, we agree with what the lower court said. So there's either no compelling or no prejudicial error that was found. In other words, everything was on board. All the evidence proven or provided was factual and accurate and allowed. Nothing happened that would cause an issue. And so we have to agree with the lower court and we deny your appeal. That's what affirming is. Reversing is where the judgment becomes the opposite. In all cases, it's instead of being found guilty, it's being found not guilty. And this happens when a significant error was found. So if they looked at the case and they realized, holy crap, they presented evidence that was not only fabricated but straight out lies. Yeah, that was an error of fact and that was an issue. And so therefore we have to say, as the judges on this, that you were charged incorrectly. We reverse your original sentence. Okay? So affirm is agreeing with the lower court decision. Reverse is overturning it. Remand is different. Remanding is where you send it back to the trial court with new instructions. This is usually because maybe not necessarily an error of fact, but an error of procedure, where something wasn't followed right, or somebody wasn't given the proper information, or jury deliberations were intentionally worded a certain way to go for a certain punishment. If there's something that's not right, but the person still potentially was guilty, what they can do is remand it, which means they can send it back to the lower courts and they can try to do a new trial, or they can adjust the sentencing based off of those new instructions. So please note, remanding doesn't mean that you just reverse the sentence and boom, you're found not guilty. That's reversing. Remanding says, hey, something was wrong. Here are my instructions. This is what you got to follow through and do correctly. You can either take it to a new court case or you can just adjust those things and try to figure out a new sentence. These are the three actions that an appeal court does. These are the only three responses they have: affirm, reverse, or remand. I'm saying this because in the past, students have gotten this wrong on the exam. These are the three actions that an appeal court has. All right. So, as I said, federal courts. There are federal trial courts, intermediate courts, and intermediate appeal courts and high appellate courts. The federal trial court is the U.S. district courts. These are the most common courts. There are 94, 96. There's 90-something of them. I forget off the top of my head, and I don't have it written down in my notes off the top of my head. I apologize for that now. But the federal trial courts are the ones that hear those typical cases. They're the ones that you present the evidence to. Then you have the intermediate or the appeal courts. And so here in the United States, we have 13 circuit courts. These are the Court of Appeals for the federal government. PA is part of the Third Circuit with Delaware and New Jersey. So the Third Circuit Court is our appeal court for any federal cases that we wish to appeal our case to. And then the highest appeal court in the United States is the Supreme Court of the United States. So SCOTUS, S-C-O-T-U-S, that is the abbreviation of Supreme Court of the United States. If you see me write that down ever in anything, that is what it stands for, okay? So there is something important to talk about with this. Oh yeah, sorry, I forgot to say that after trial in a district court, the losing party has an appeal to one appeal of right, or in other words, a right to be heard. That's a whole other thing. But you cannot appeal not guilty verdicts, but you can appeal guilty verdicts. And specifically with Supreme Court, sorry, I kind of got distracted in my own notes, but Supreme Court, they're what is called a discretionary court. And what that means is they have this very interesting power to choose what cases they hear and what cases they don't. Now, technically, a lot of judges have that power. It's a little bit more complicated than that. But very specifically for the Supreme Court, what this discretionary power looks like is that they choose the most serious cases that they believe will have the biggest impact on the whole of the United States. So just because you went to federal court doesn't mean that your case will be, when you appeal, heard by the Supreme Court. If it has something that they believe has an impact on the whole of the country, then yes, that's a possibility. But very specifically, asking for an appeal from the Supreme Court is asking for what is known as a writ of certiorari. I told you that word was going to come back. The writ of certiorari is just the term used for requesting an appeal from the Supreme Court, or really from any appeal court, but it was worth noting here. When it comes to the state courts, as I kind of teased before, they mirror the federal court structure. They do have the trial courts, they have the Court of Appeals, and most states have a state Supreme Court. It doesn't have the same power as the Supreme Court of the United States, but it is still a high appeals court that will hear these types of cases and make claims that will have a larger reaching impact on the whole state rather than a small community. So the other thing, though, is they have small claims court. And these are for what can be referred to as trivial. And what I mean by that is low impact, low cost. Really what they're looking for is financial impact and financial damages. They're not really, criminal cases. That's where the state trial courts come in. Those are the all-purpose courts. They hear criminal issues, but they also hear some civil issues, especially if they're not necessarily only financial. And then obviously, as we said, the appeal courts do exactly what appeal courts are supposed to do. They listen to claims, they look at the evidence, and then they make a choice whether to affirm, reverse, or remiss. Remand, not remiss. Sorry. See, even I struggle with the terms. I don't expect you to memorize them, but I expect you to know them. All right. And this leads us to, unfortunately, the discussion about our system itself. And within the court system, we have what is known as the burden of proof. And the burden of proof is a party's responsibility to prove a disputed charge, allegation, or defense. I use those terms very specifically. And the reason is, I'm going to jump right down to the last thing on this slide. The burden of proof is often on the plaintiff in civil court or on the prosecutor in criminal court. So for the most part, the burden of proof, the amount of evidence you have to have, is on the person charging, not on the person defending. But you'll notice I say it's the party's responsibility to prove a disputed charge, allegation, or defense. Charge and allegation, that's on the prosecution, on the plaintiff. Defense is on the defendant. And we'll talk about that later when we actually talk about legal defenses, but it's important to note now. So the burden of proof requires two components, the burden of production and the burden of persuasion. The burden of production is the obligation to produce and present evidence to the finder of fact in the case. Quite literally, the two components for the burden of proof is, number one, you have evidence. That's the burden of production. You have to present evidence. You can't just say, well, yeah, I know it because it happened. No, you need to provide physical evidence to this. And the other burden is the burden of persuasion. It is on the person who is bringing the evidence to, it's their duty to convince the finder of fact, the judge or the jury, to a certain standard. And the standard we typically talk about is beyond a reasonable doubt. We'll talk about that here in just a second. Important to note, enough of one should provide the other. Enough burden of production, enough physical evidence should be enough to convince the trier of fact. That's an important piece to state because we're going to see that there is issues with this as we kind of dive deeper. Okay, yeah. Before I jump into that, one thing I've been kind of saying is just a brief reminder that there's a difference between a bench trial and a jury trial. A jury trial is a trial where the finder of fact is a jury of your peers. A bench trial is where the judge is the trier of facts. There is no jury. What is important to note, and this is what's related to the other text that's on Blackboard, is about the PA jury thing. Since jurors are your peers, they're not legal scholars, they're not experts, judges will often guide jurors on what the burden of proof is in their jury instruction. What is kind of important to note is that not every state has this. or rather, not every state has rules about it. We're going to talk a little bit about it, not in the next slide, but the following slide. So, when we're talking about burden of proof, like I said, there is a difference between civil cases and criminal cases. This class is criminal law, so we're going to talk way more about the criminal cases. Those are the things we're going to be looking at, but it's still important to understand how it relates to civil cases. So in civil cases, this is referred to as a preponderance of evidence. And what that means is that the plaintiff needs to produce slightly more and slightly better evidence than defense. The reality is, in a civil case, this is a relatively low standard. We're talking 60% of the evidence presented to persuade a group of people. That's all you need for a civil case. In criminal cases, this is the most challenging, as it requires that term beyond a reasonable doubt. What's frustrating here is that there is not a clear or easy definition for beyond a reasonable doubt. This is a subjective term, but it's also one that we understand. If I told you what explain to me what beyond a reasonable doubt is, it's difficult to explain, but you understand what it means. So the best way I've heard it described without using the words beyond a reasonable doubt, the best way I've heard it explained is if somebody else who had no experience, no knowledge, heard all this, would they believe it? That's beyond a reasonable doubt. We're looking at 98%, 99% of the evidence makes perfect sense to a random stranger. That's beyond a reasonable doubt. So, traditionally, the prosecution's evidence must overcome or supersede the defendant's presumption of innocence. Remember, in our system, we believe in the concept that innocent until proven guilty. That's a whole other complicated matter. But the idea is that for evidence for a trial to work, they have to have it beyond a reasonable doubt. You have to hold up all the evidence against the belief that the person is in fact innocent. That's the important big takeaway here. The burden of proof is complicated. So, to meet the burden of proof, two different tools can be used: inferences and presumptions. And I know this sounds kind of dangerous, but it's important to understand that inferences are conclusions the judge or jury may make under certain circumstances. Presumptions are conclusions that judges or juries must make under circumstances. And if you're like, okay, what's the difference? An inference is something that may be made. It is not a guarantee. It is something that you can reasonably believe. A presumption is a estimate that has to be made. The big issue here is that all criminal defendants are presumed innocent, which means they are innocent. And that's a presumption. The presumption is all criminal defendants are presumed innocent, and they are innocent until the evidence is proved against them. Inferences are not mandatory, but choices where you can look at evidence and you can make a logical decision to say, yes, I see how that connects to the other thing. They have to presume innocence. They can infer guilt. And how these break down are both of these can be rebutable or unrebutable. And all that means is whether they can be debated or not be able to be disproved. And so, like I said, the burden of proof is difficult, and because jurors are not legal scholars, they have to be guided. And PA does not have a state standard definition for the burden of proof. And believe it or not, it can vary from judge to judge. For the most part, we have some general guidelines that are available online and that a lot of judges use, but it is not a mandatory piece, at least here in PA. All right. Now we're on to the last slide. And holy crap. Let's talk about evidence real quickly. And the reason why I say that is it's going to be relevant in a different lecture at a different time, but it's still important to mention it here because, well, it does actually, play a role into some other things. And so there are two different types of evidence. There's circumstantial evidence and direct evidence. Circumstantial evidence indirectly proves a fact, whereas direct will, quite literally, directly prove a fact. This is where I blow some people's minds, and I know this is hard to grasp as a concept, so please bear with me. Fingerprints, DNA, clothing fibers, all of these things that we understand as hard science evidence are simply circumstantial evidence. Just because their fingerprints were at the scene of the crime does not prove that they committed a crime. It proves they were there, but it does not prove they committed the crime. If their fingerprint is on the murder weapon that was found at the scene of the crime, where their DNA was also on other parts of the area and was on the body and mixed in with the blood from the victim, that's a lot of circumstantial evidence that will directly point to guilt. But just having fingerprints, just having DNA, those are circumstantial evidence. And I know, again, it's controversial to say that, but it's important to note that they don't prove the fact. All they do is indirectly prove it. They prove you were there. They didn't prove you committed the crime. Eyewitness testimony, confessions, and surveillance photos and footage and things like that are considered direct evidence because they prove a fact directly. Now, I will say, we understand that there are issues of legitimacy with eyewitness testimonies. We understand that confessions can be manipulated and designed. We also understand, especially now in the era of AI videos getting better and better, that there is legitimate issues of footage and photos, or whether or not they are real or doctored, which turns this whole concept of direct evidence and circumstantial evidence on its head. Can we trust it? I don't know. This is a complicated matter that we are just starting to delve into in our system now. And it's important to note that. So, I want to wrap up this particular piece with saying, despite DNA evidence and fingerprints being circumstantial, the reasonableness of innocence with this unique type of evidence typically meets the burden of proof. Okay? So even though we would consider it circumstantial because it doesn't directly prove the fact that it is hard to fake that makes it more valid. So hearing somebody say hearing somebody say that you need more than circumstantial evidence to prove a crime happened, that's fair. But when you have a lot of circumstantial evidence that builds onto itself, that makes it a good argument. So again, don't take it as, oh, it's not usable. No, it's very usable. It's just different than how we necessarily think and believe. That should be kind of the motto going forward, that law is weird and worded weirdly and differently, and what you think you understand kind of goes in different directions. But that being said, that's it. That's the notes. Obviously, if you have any questions, please reach out to me and let me know. I think this was a pretty good lecture. I think I covered all the important things. that you needed to hear for week 2. But yeah, by all means, please watch this before you do your case study response. I'll give you the hint. This is my, you stuck around long enough, you get a little bonus. The answer to number 3, what type of case is this? Almost every single case study response you are reading and working on will be an appeals case. So there you go. I just gave you an answer. See, this is why you stick through all the way to the end of my lectures. You get a little bonus. All right, thank you very much. Good luck on the case study response. Let me know if you have any questions, and I'll see you all in the next video.